Hello, my name's Gregory Brown. I'm a partner with the law firm of Brown and Charbonneau, and today we're going to talk about breach of contract. To prevail in court on a breach of contract claim, you must prove four elements. First, you and the other party had a contract. Contract requires that one party extend an offer, the other party accept that offer, and both parties exchange consideration. That is something of value. Proving a written contract that is signed by both parties usually is not difficult. However, the other party may deny that you reached an agreement if your contract is oral or set out in a series of emails or memos with conflicting terms. Now, second, you substantially performed your contractual obligations or had an excuse for not performing them. You must have done what the contract required you to do unless you were excused. Now, two common excuses for non-performance are one, the other party was required to perform first and it never did, or two, the other party prevented you from performing. Now, the third element is that the other party breached the contract. A breach of contract is an unexcused failure to meet an obligation imposed by the contract. A breach can occur when a party does not perform at all, or performs but is not up to the contract specifications, or does not perform on time when timely performance is essential. Now, the fourth element is the breach caused you to suffer a quantifiable economic loss. Arguments in breach of contract cases often center on damages. Sometimes a defendant will admit the breach and contest the amount of damages. A plaintiff in a breach of contract case may potentially recover three types of damages: expectation damages, consequential damages, and incidental damages. Now, expectation damages put you in a position you would have been had the breaching party performed. Consequential damages, on the other hand, are losses caused by the breach beyond the contractual loss, such as lost profits. The losses must be a direct result of the breach, and they must be foreseeable. Finally, incidental damages are generally damages of expenses incurred by a party in connection with the other party's breach, such as storage or shipping costs. When the other party breaches, you must take reasonable steps to mitigate your losses. That is, keep them at a minimum. You are not entitled to recover damages that you could have avoided. How much proof do you need? Well, you must prove each element by a preponderance of the evidence. Now, a preponderance means basically more likely than not. In other words, the jury must be more convinced by your evidence than by the defendant's evidence, even if it's just a little bit. Overcoming any evidence that the defendant presents and proving the four elements does not guarantee success. There are more than a dozen affirmative defenses that a defendant can claim. Some of the more common affirmative defenses include the plaintiff filed suit after the statute of limitations had expired, or an unforeseeable event or act of nature made the defendant's performance impossible or impracticable. Another one is the defendant agreed to the contract because of duress, undue influence, fraud, or misrepresentation. Or the contract is unconscionably one-sided in the plaintiff's favor, or the plaintiff waived the defendant's performance. Now, for example, the plaintiff can't claim a late payment breached a contract if it always accepted late payments, although there is an exception to that in some contracts. So, to recap, to get a judgment in a breach of contract case, you must prove each of the following elements by a preponderance of the evidence, which is more than 50%. First, you and the other party entered into a valid contract. Next, you performed your contractual obligations, or you have a justification for not performing. Third, the other party failed to perform its contractual obligations. And finally, you suffered a loss or damages as a result. Now, the defendant can contest your proof and need only convince the jury that you have failed to prove one element to prevent you from getting a judgment. The defendant may also raise affirmative defenses that could prevent you from recovering even if you prove the four elements above. For more information about this topic or other business-related disputes, call us today at 714-505-3000 or email us at inquiries@bc-llp.com. Thank you.